Good morning. So before we get started, let me turn the mic over and we'll have a message from JC Restoration.
All right, everyone, good morning. Welcome to JC Restoration. Real quick here, quick show of hands. Can I see who's been here before? Are we all newcomers? All right, a couple of you. Well, welcome back. If this is your first time here, welcome. We are thrilled to have you. We are a fire and flood restoration company. So what does that mean? We have the ability to put a property back to pre-loss condition after it's had some damage, whether it be a fire in a home or a building downtown. When we have all the crazy rain that happened last July, we were getting a bunch of water calls in, so we are able to help with all the water damage in homes when it gets to be storming outside and all of that. We do roof stuff too when the trees fall on the roof and we have water leaking in. We can handle that whole entire project. So anything with property damage is what we can handle, small or large. So any questions, I'll be out in the marketing office if you need me, but enjoy.
So good morning again, and welcome to our second risk seminar in the 2018 CDH Risk Seminar Series. And we are excited to be here at JC Restoration, and we're excited to be able to team up with DSP Insurance Services and Querrey Harrow to present this seminar about product liability. So today's seminar is built around case studies involving actual product claims that we will use to highlight the risk and the steps that you can take to mitigate product liability risk. And so without further ado, I'd like to introduce our speakers. Our first speaker is Mr. Taylor Virgil. Taylor is with DSP Insurance Services. He's an experienced engineer and business advisor. He spent the early part of his career honing his engineering skills with Lockheed Martin Aeronautics Advanced Development Programs, also known as the Skunk Works in Marietta, Georgia, and Palmdale, California. As his career progressed, he transitioned to consulting and business advisory, where he leveraged his engineering knowledge to consult for a variety of clients on operational efficiencies, technology, and risk management. He employs a process-driven approach to connect the dots for his clients on complex risk issues. Taylor holds a BS in Industrial Engineering from the Georgia Institute of Technology, where he graduated with high honor. Our second speaker is Mr. Tim Rabel of Querrey Harrow. He has been doing commercial litigation for over 20 years. He has litigated complex contract cases and breach of warranty claims. He has also drafted and negotiated contracts, warranty provisions, and terms and conditions for manufacturers, distributors, and suppliers. He has a BA from the University of Illinois and a JD from the John Marshall Law School. Our next speaker, Mr. Bruce Schumacher of Querrey Harrow, is an experienced commercial attorney who also does product liability defense. He has worked with many manufacturers drafting and negotiating contracts, including sales and purchase terms and distributor agreements. He has defended and coordinated the defense of product liability claims made against truck component, industrial product, and agricultural product manufacturers, and a major chemical distributor and blender. He has a BS degree from Northwestern University and MBA and JD degrees from the University of Chicago. And our final speaker is Mr. Bobby Schutz of DSP Insurance Services. Bobby began his career with Chubb Insurance in Denver and San Francisco, working exclusively on professional liability for venture capital and other financial institutions. After joining DSP, he applied his experience with professional liability to common Midwest industry, particularly advanced manufacturing and heavy construction. Bobby has worked with many manufacturing clients, reviewing and drafting insurance documents to mitigate liability to the fullest extent of the law. Bobby holds a BS in General Business from the University of Denver. So with that, I will turn the mic over to Taylor. Thank you.
Actually, before Taylor goes in, I'm just going to give a quick recap of what the agenda is. So this particular instance was a case that Taylor and I were involved in. We're going to lay out what the case was, what some of the insurance issues were, and then we're going to pass it over to Ken and Bruce, and they're going to walk through how to mitigate the risk as much as you possibly can. Then we're going to hop back into the case and kind of change some of the scenarios that would trigger a different suit that might be brought based on that. And then at the end, we'll give you kind of some best practices that you can do, some things that you should be looking for, trends that we're seeing in manufacturing, and by all means, if you have any questions, want to discuss it further during the presentation, feel free to interact. We've got a pretty small group here. Try to make this as interactive as possible. So, thank you.
So again, I'm Taylor Virgil with DSP Engineering by trade, and have been recovering from that for a few years, and joined the dark side of insurance. I kind of want to lay out this case study, starting with the product, talk a little bit about, the scenario and how the product is being manufactured, and really lay out, where the insurance kind of comes into play. Again, this is a case that Bobby and I were involved in, and it's just pretty interesting to see how it all ended up playing out from a coverage standpoint. And then we'll let the lawyers jump in and talk about the legal aspect. So to start, we have the product right here. It's they're joysticks, and not for video games, but for excavators. So you think, Caterpillar and Komatsu, and those big kind of heavy industrial equipment. And they're manufactured by kind of a mid-tier manufacturer to OEM specs. So, what does that mean? Most of you guys are probably familiar with. The OEM actually makes the design, and then they subcontract out that build to a smaller tier manufacturer, and then they ship it back to the OEM to go into the final product. This is kind of a flow chart. Again, you guys are probably familiar with how this works. During the process, there's also some recommendations and back and forth between the OEM and the actual company manufacturing it, and there can be some changes. So the OEM engineers have it designed, the manufacturer looks at it, they say, hey, this is going to be more efficient to maybe use this material here, or make a cut this way, or have a bolt or a screw here. They go back and forth, and then the OEM actually has the final sign-off before the product is sent to be placed into the bigger parts. It's all done by purchase orders. That's the contract in this scenario, and that's how the joysticks are going to get to the manufacturer. So this particular scenario, these joysticks were made. A bunch of them were sent to be installed. This is just an example. This isn't the actual picture, but what happened is they were going into bulldozers, and there was a sticking issue. So when they were driving or trying to direct it, it would get stuck, and it would cause them to keep going and not stop. And they found this out during the install phase, and obviously ran into a lot of issues because you don't want this happening. Luckily in this scenario, this never happened, but there's still a huge issue in terms of, hey, we've made a ton of these parts, we've shipped them out to the destination to be installed, now we're running into an issue. What actually happens here, because there hasn't been a scenario where there's any property damage or bodily injury, but yet there's still a claim scenario. So what happens in this scenario where, again, there's no bodily injury or property damage? Well, the OEM has a huge issue, as well as the middle tier manufacturer. The OEM is now missing deadlines to get final products out to their customers. The OEM suffered a loss of roughly $250,000. The manufacturer all of a sudden gets saddled with a bunch of investigation costs. They have to fly across the country. They have to get their engineers involved. They have to figure out what went wrong and kind of do a root cause analysis. That takes time, that takes money, that takes effort. Again, no bodily injury, no property damage. Question?
Is the $250,000 the lack of sales?
Yes.
Or is that something other category?
It's a combination of everything.
Yeah, so that's just the total loss in this scenario. Lack of sales, delays, contractual issues where, hey, you need to have a product delivered by this time and date. You're missing that. There's penalties. There was a recall, so then now we have to go and we have to ship everything back. We have to start fixing it. We have to do re-engineering. There's labor associated with that. There's time associated with that. And then there's a lawsuit. Always ends in a lawsuit. And the OEM wants to recoup the money that they're losing. So this settled out of court for a non-disclosed sum. We see that happen a lot. But again, this is kind of the scenario I wanted to lay out from an operational standpoint for you guys, because you're probably very familiar with this. And then I'm going to turn it over to Bobby and have him kind of bring up a couple more of the insurance points.
Yeah. So Taylor already touched on it, but did anybody catch why you might have an insurance issue here? Why there might be an issue where this claim would not be covered under the general liability?
Bodily injury, property damage.
Yeah, so Taylor stealing the thunder, but so specifically with regards to general liability, the policies in general liability will say something along these lines. Subject to all terms and conditions of this insurance, we will pay damages that the insured becomes legally obligated to pay by reason of liability imposed by law or assumed under an insured contract. So, and then it'll go further and say for bodily injury or property damage caused by an occurrence to which this coverage applies. So in this particular instance, because there's no property damage or any bodily injury, that loss will not be covered. So the next question I have is, how many people in here purchase manufacturing errors and emissions in some capacity? Does anybody buy it? So that's also a trend that we commonly see. Manufacturing errors and emissions is not a very common coverage that people buy currently. We're going to go through that a little bit at the end, but realistically what we're trying to lay out here is you have an uninsured loss. So now what we want to kind of go through with Tim is, because you have an uninsured loss, we want to give you some tips, recommendations, best practices as to how to defend yourself in this situation so that you have as minimal balance sheet exposure as possible. So,
morning, everyone. I do have a lapel pin, but I've never been told I'm a soft speaker, so if I don't need to turn it on, I won't. Does this go backwards? Can I go backwards?
Yeah.
Look. There we go. That happens often, believe it or not. In a video game, we would just press restart or start over, but that's not going to happen here today. So, all right. I'm a lawyer, so I have to put a disclaimer up here, like lawyers do. I'm not giving you legal advice. This is just an educational seminar today. If you have any specific questions regarding your particular scenario, we'd be happy to talk to you, but consult your own lawyers. This is just a general overview. I don't have a whole lot of time to talk about everything in detail, so this is really just kind of a general discussion about sale of goods, which is what we're talking about in terms of components, products, that type of thing. And we're talking about it in the terms of a commercial relationship where you have a contract between the parties, the manufacturer, the purchaser, suppliers. That's where my discussion is relevant. We're talking about the commercial relationship, the negotiations, the contract, or in the scenario we were given, the purchase order. However, the purchase order is generally not the only document that's involved with these manufacturing and sales processes. The purchase order is maybe a response to a request for a bid or a proposal, and you get into this concept of the contract and what is the contract. And that's my analysis, is what you could put in your contract to address some of the issues that are raised by the scenario that we were just talking about. Another caveat, I'm a lawyer, so we're going to start out with an assumption here. And it's a big assumption because it's not always true. We have a lot of foreign manufacturers involved. We do a lot of purchases of materials and equipment from overseas. Work is going to be performed in other countries. Work can be performed here. So one of the big questions that arises is what law applies to the transaction and what law is addressed in terms of the relationship between the parties. I'm going to talk about the Uniform Commercial Code, which is the UCC. It's a general code that has been adopted in one form or another throughout the United States. So when you apply the UCC, you're talking about applying U.S. law to the transaction. What law applies is frequently going to be addressed in your documents, your contract, your purchase orders. And there's a whole other presentation that we can do in regards to what is the applicable law for the contract and the transaction. But as I said, I'm going to talk about the Uniform Commercial Code, which deals with the sale of goods. And specifically, I'm going to talk about the Illinois Uniform Commercial Code. The UCC is it's a form code that is adopted in one form or another throughout the country, and it addresses the sales of goods. Particularly what we want to talk about is Article 2, which addresses the sales of goods over, yes?
Do you find that since many components are being manufactured outside the U.S., are those organizations becoming more knowledgeable about the U.S. commercial code?
Contract law in general, yes, whether it's specifically because most of the agreements will have provisions that address the UCC. Another seminar could be on what's called the Battle of the Forms, which is a negotiation of, I send this document that says these are the terms of the sales and purchase. I respond back with a document that says, well, here are my terms and conditions for the sale and the purchase. Who's control? There's a whole analysis as to whether it is additional terms, material terms, do you even have a contract, and the contracts that are coming in from other countries will have provisions in it that address the UCC to attempt to address some of the things that I'm talking about or will be talking about in terms of warranties, limitations of liability based on warranties, limitations on adopting or presenting and having additional terms added to the sale contract. You know, for the UCC purposes, generally you need quantity, price, and identification of product. But you know, if we had that simple contract, we wouldn't be in business. We have to put all this other stuff in there to address liability, conformance with the plans that are being drawn, or engineering details for the product. Who's responsible for all that? And in that last scenario, it was said the joystick was manufactured according to the plans and specifications. We don't always get that right away. A lot of litigation arises out of who is responsible for the defect in the product. Okay, under the UCC, when you're talking about products over $500, you have the right to inspect it as a buyer. So you want to address in your contract documents about your right to inspect. You can control when, where, what constitutes acceptance of the goods in terms of your purchase order. That's provisions you want to put in your document because you might get a shipment of hundreds and hundreds of pieces or parts to components, and you can't inspect everything. So you're allowed to do a reasonable inspection under the UCC. You could address that in your purchase order in terms of what constitutes time to accept and inspect and accept the product. Now, when you're talking commercial context, you're talking about contract and terms in the contract, and a term that pops up all the time is what's considered a warranty. Anybody familiar with the warranties and the term of warranty? Okay. A warranty is basically a representation, whether it's an express, implied, and I'll talk a little bit more about that. It's about how that product is going to perform or conform to the terms of the contract. And there are various warranties that are in the UCC. And since we're talking about generally manufacturing of component parts, we're probably over that $500 limitation. I don't assume anybody's only selling $500 worth of product or components here. So there are a variety of warranties within the UCC, and those will be implied in your contracts. or you can address them specifically in your contracts and your purchase orders. Identifying what they are, limiting them, making express ones, waiving them. I'll talk a little bit about that. Okay, so an express warranty, that's some affirmation, promise, or description, or even giving a sample of a component or product, but you don't actually have to use the term warranty or guarantee in your contract. So what does this mean? If you're giving an express warranty, 90 days on a product, a year, against manufacturer's defects, etc., that's what you're talking about. You can control that warranty, that express warranty, by the terms of your purchase order or terms of your contract. You write in it, I'm giving you a 30-day warranty. Buyer might want a 1-year warranty. You negotiate that back and forth in terms of what is the express warranty's duration and exactly what is being warranted. Also within the UCC are these implied warranties. Now, implied warranties, anybody familiar with that concept? What's implied? Anybody have a guess as to what that means, implied warranty? An implied warranty are those warranties that the law is going to read into the agreement, even though it's not expressly stated in the agreement or in your purchase order. Why that's important is, unless you address that in your written documents, you might be as a seller, might be undertaking and providing an implied warranty as opposed to eliminating that or limiting that in your documents, which results in potential liability for you. So one of the implied warranties, the implied warranty of merchantability. This is basically the warranty that talks about products have a general acceptance in the industry, and that this product or component or whatever is being sold, the good, is going to pass without objection in the industry. It's going to be of fair average quality, fit for its ordinary purpose, without variation. The packaging that's coming in is adequate in terms of labeling, and what's in the package actually conforms to the label. So in the joystick scenario, the implied warranty is this is going to work like a normal joystick in the industry. Whether it's manufactured by this entity or it's manufactured by this entity, there are certain industry expectations as to how that joystick is going to function. Another implied warranty is the fitness for a particular purpose. This is where, based upon the relationship of the parties, the seller has an understanding as for the use of that particular product, and that there is a warranty that that product will be sufficient for that buyer's purpose.
Yes. A question in regards to this implied warranty and other warranties. So typically, how many people operate with purchase orders, just purchase orders? You guys use purchase orders? Does anybody actually use a contract? We have one person has a contract. So in the implied warranty, is there language that we should be looking for? Am I right?
We're right here.
There we go. Take over.
It's coming up on the slide how to limit or waive or deal with the warranty. So okay, we'll do that. Okay. I have a question for somebody. Please answer. Your purchase orders, how long are they? Page? Okay. Does it somewhere in there say this purchase order is subject to terms and conditions that are located on my website or on another document? That's sometimes and frequently the case. So although you might be dealing what you think with is a one-page document, which is a purchase order, those terms and conditions that are properly incorporated make up your contract. And that's where you're going to find a lot of what I'm talking about. Your purchase order is not going to have a whole lot other than this, I'll give you this amount of money for this number of pieces of whatever you're ordering. It's the terms and conditions that control and have a lot of what I'm talking about in terms of waivers of warranties, limitations of warranties, inspections, waiver of damages, that type of thing. Yes?
As a lawyer, wouldn't you recommend that you get everything on a document as opposed to, it's on our website? Because websites change a whole lot.
Yes, but the typical way when we negotiate a contract is you want to see everything that's applicable at the time you enter into the agreement. It is now the practice to have terms and conditions posted on a website, but it has to be incorporated correctly within your document, a link, identification, and you should be aware and read everything, whether it's in manufacturing process or whether it's in a construction contract case where there's a reference to all these other different documents. You know, the law is going to say if it was identified, you had the opportunity to review it, and it was given to you. If you don't read it, that's not going to save you. So the implied warranty, here we go.
There you go.
Those are the warranties. The express one you control by what you say and you put in the document. The implied warranties are read into it, but you can waive them, you can modify them, you can change them. And this is if you go and you look, and the UCC requires that these modifications and waivers be offset from the regular type and print of your document. It's going to be the one that's in all caps. It's going to be bold. The document's going to say something like, you know, there are no warranties as to merchantability or fitness for a particular purpose. These goods are being bought as is with all faults. And that if it's these requirements of UCC, you can limit that warranty or even waive it if it's sticking out and it's part of the contract. Okay. Breach of the warranty is basically it's a breach of contract. It's a breach of an element of the contract. So if in the scenario with the joystick, once you identify what the issue is with the joystick, the buyer can have a claim against the seller. We talk about costs to investigate, go across the country, figure out what's going on. Those are potential areas of damages that you can recover upon for a breach of contract or a breach of the warranty. For my presentation, under the commercial context, your damages are different than what Bruce is going to talk about later in terms of the change scenario, where you have that damage to property or you have that injury to a person. The UCC has some of that in it, but it's not as broad and it's not provided as great a protection for some injured party in terms of whether it's a personal injury or property damage. Now, under the UCC, one of the things that a buyer could get is a difference in value. What is the value of the product that they received versus what the value of the product would have been or should have been in terms of if it conformed with the requirements of the contract. You could also get incidental damages, which is basically the damages that you were talking about. What are the actual out-of-pocket costs as a result of this failure of the product to conform with the requirements of the purchase order in the terms and conditions? The other item that you can get is the consequential damages in the right scenario. That's the lost profit or the interruption of business that results from a non-conforming product. These two can all be waived and modified in terms and conditions. So when I talked earlier about the battle of the forms, seller is going to limit all this stuff. If you read it, the seller is going to try to limit the warranties. The seller is going to try to limit its exposure on damages. Conversely, the buyer is going to throw terms in their document that say X, Y, and Z, and you're going to have potential conflict. And there's a whole, like I said, that's a whole other presentation. The one thing that the UCC is not good with is in terms of damage to property and injury to person. And Bruce is going to talk about the law in that regard. The UCC is not developed for that type of scenario, although there is one instance where a personal injury plaintiff could recover under the UCC. That's somebody that's hurt by the product. That's in the example of like the household member or somebody that's injured in the house. These warranties can extend to the person who ultimately buys the product, as well as somebody within the house that might be injured when they're using the product. So that's my presentation. And as I said, they're going to change the facts a little bit now, and they're going to go into the issue that's going to lead into Bruce's presentation. Yes, Bruce.
Before we do that, I'd like Bobby to put back up on the screen the photograph.
Okay.
And we were talking, Bobby was talking about property damage and bodily injury. And when we talk about property damage with reference to the general liability insurance policy, we're talking about physical damage to property, okay? And one thing we kind of said just generally, it's just general, we speak in generalities when we're talking at seminars. We can't talk about every specific episode. There is damage in that policy, in that photograph, that is covered by your insurance policy, and damage which is not covered by your insurance policy. So if we manufactured the joystick and we have a general liability policy, and our joystick is defective, and that caused that bulldozer to run into that part of the building and cause property damage, that's physical damage to property. That part of the claim is covered by your insurance policy. So that's why it's very important when you get into these situations or are strictly commercial situations, dispute between you and your customer. It's very important when you get to a situation like that, that you talk to not only your attorney, but also your insurance broker. Because what you want to do in a situation like that is you want to report this accident to your insurance broker, who can then report it to your appropriate insurance companies. They then have a duty to investigate to see if there's any coverage. If they say there may be coverage, they owe you a defense, which means they have to pay your attorney's fees. They have to retain an attorney to defend you. But more important, because there's both covered and not covered damage in that claim, the insurance company has a conflict of interest. So not only do they have to advise you that you have a coverage problem, and some of this may be covered and some of this may not be covered, they also have to advise you that we will let you retain or hire your own attorney, and we, the insurance company, will pay the bill. And you get the right to basically control the defense of the claim.
Yeah, well, you already kind of jumped into it, but essentially all we're doing in this situation is we're eliminating the manufacturing errors and emissions exposure that you have. So this case that Bruce is going to run into purely goes through, in reality, what happened is the customer identified the problem before they started using it. But when they were starting to drive these machines, it got stuck. And you could imagine the exposure that they had if it hit a school bus or ran into a building. And we actually see that quite common. So all we're doing here is changing the scenario and playing a pretend game and saying that joystick failed while it was on the road. And during the process, it ran into a building. So with that, again, you've got some covered matters, some not covered matters, but realistically, you want to start defending yourself, and that's where Bruce is going to go through the process and some of the recommendations.
You go back to the scenario. Let's change the scenario a little bit. You saw the photograph with the bulldozer that hit the column inside this warehouse or whatever it was. That's covered by your insurance policy. Let's change the scenario a little bit. Let's just say, unfortunately, under the bulldozer, there's a man, and he's injured very badly, okay? So, because he's injured, he's going to go and get an attorney sometime and say to the attorney, how do I get paid for all these injuries I suffered? The attorney, of course, will say, well, we'll sue the people who caused your injury. And so the attorney will say, we will sue the manufacturer of the product because the product was defective because this joystick stuck. So the attorney, on behalf of his client, the plaintiff, will sue the bulldozer manufacturer, and the joystick was stuck. He'll sue the joystick manufacturer, and he finds out the part was defective. He'll sue the part manufacturer, all right? Each of these people should be covered by their general liability policy because there's bodily injury. The poor man who was run over by the bulldozer. Now, Tim was talking about contracts in commercial situations. And often we see in the purchase orders or sales orders or the blanket contracts that our clients sign that the buyer has certain provisions in there which require the buyer to be defended by the insurance company. We also find the seller's insurance company. We also find provisions in contracts where the seller will say, we're not responsible for any personal injuries. The buyer will hold us harmless for that. The important thing is to realize anything you say in a contract to protect yourself in a commercial situation does not apply to a claim of an injured third party because they're not part of the contract. So the injured third party under U.S. law can sue the manufacturer of the product for a product defect which caused them injury. And in the U.S., most of the product liability cases are what we call strict liability cases. In a strict liability case, the party who is injured has to show in court that he or she sustained an injury, right, a bodily injury. Second, they have to show that the injury was caused by a defect in the party they are suing. And then, of course, then the defect caused them to lose money, damage. Also, if you are sued for the product liability claim, you also may be sued for your negligence or also finally, third point, for breach of warranty. The important thing is that in a strict liability case, the plaintiff has to show a defect in the manufacture of the product, the design of the product, or some defect in the instructions or warnings for the product. And the way they show this is they get an expert witness. And the expert witness will go over the accident, what caused it, he'll look at the products involved, and he or she will determine what may have been defective. Was it defective in the way it was manufactured? For example, was there a defect in the casting? Was there a defect in the design? Did they not take into account various structural stresses on the product? And third, they'll look at the instructions and warnings to see if the instructions and warnings adequately warned the user of the product that there may be something defective with it. So, in a strict liability case, the manufacturing defect has to be in the product when it left the manufacturer's control. The design defect must be in the product when it left the manufacturer's control. And the failure to provide adequate warnings and instructions has to be in the written material, or there's no written material at the time it leaves the manufacturer's control. Now, in a strict liability case, the distributor of a product, only in a strict liability case, a distributor of a product in Illinois is not, can be sued, okay? In a product liability case, anyone in the chain of a sale or chain of marketing the product, the manufacturer, a wholesaler, a distributor, a seller, even maybe a commercial lessor, any of them are potentially liable for a defect in the product. So if you're just a distributor and you never touch the product, you could be held liable for a defect in that product, which was put there by the manufacturer. However, in Illinois, we have a special statute which protects distributors and retailers. Yes, sir?
You're the manufacturer and you don't have any control on design.
I'm sorry, what?
If you're the manufacturer of the product and you don't have any control of the design.
Okay. You're mentioning the situation of what we call the fabricator situation. If the fabricator has no control over the design of the product, then he or she is not liable for any injury because of that design. The designer, which will be the OEM, usually would be responsible to the injured party, okay? However, under strict liability law, anybody in the chain, anyone who sells the product can be held liable for injuries because there's a defect in the product put there by the manufacturer. Now, in Illinois, we have a special statute which protects distributors and retailers from product liability claims for which they are not responsible necessarily because they didn't put the defect there. but under the strict liability law, they can be held responsible. So they put in a special provision in Illinois to cover that situation, which says that the defect has to be in the product before it gets to the distributor. And the distributor has to show that he or she did not have any knowledge of the defect, and that they were not the manufacturer of the product, and they were not involved in the design of the product, and they did not provide any instructions or warnings for the product. So if they can show to the court that they meet all these requirements, then they will be dismissed from the case. And they also have to certify who identified the manufacturer of the product. Okay? And if they do that, the court has to dismiss them from the case, unless the manufacturer is able to use the statute of limitations to get out of the case. The distributor did not correctly identify the manufacturer. The manufacturer no longer exists, or cannot be found, cannot be sued here in the United States, or the manufacturer cannot pay any judgment or reasonable settlement. So that is a special statute in Illinois which protects distributors when they're sued in a product liability case when they really had nothing to do with the defect other than just sell the product. However, that statute only gives protection for strict liability claims. It doesn't protect the distributor against breach of negligence or breach of warranty claims. But it still is a start for a distributor to get out of the case. There are certain defenses that can be used in a product liability case in Illinois. First of all, in a strict liability case, the defendant, the manufacturer, cannot use any negligence on the part of the plaintiff as a defense. Negligence is not part of a strict liability case. Before strict liability became the law in Illinois and the other states in the Union, the plaintiff had to show that the manufacturer was negligent in the manufacturer design of the product. But the manufacturer then can use, in that situation, the injured party's own negligence as a defense to the claim. So you can see the strict liability theory is very favorable to plaintiffs. The defendant can use the assumption of risk defense in Illinois, which is that if the plaintiff knows there's a defect in the product that could cause injury, then that can be used as a defense in an Illinois case. The same thing for misuse of a product. There are some other defenses the manufacturer can use or the seller can use besides statute of limitations. One of those is the statute of repose, which is a statute that basically says that after 10 or 12 years from the date of manufacture, the manufacturer could no longer be sued for a defect causing injury in a product liability case. The statute of repose came into Illinois and many of the states in the United States in the 1970s and 1980s in response to cases around the country where the product had been manufactured 50 years ago or longer, and the manufacturer was still being sued for defects in those long-lived products. So I hope I gave you a little brief understanding of what happens in Illinois in a bodily injury case. Many of you will be involved in those cases down the line, unfortunately. But fortunately, you will be defended by your insurance carrier in those kinds of cases. And it's important that you work with your insurance carrier and defense counsel appointed by your insurance carrier to win those cases. Many of these cases have very good defenses. Many of these cases you can show there was no defect in the product, there was no defect in the design, there was no defect in the manufacturer. Something else caused the accident. In many cases you'll find out, especially in the automobile industry, there may be a broken part, but the big question becomes, when did the part break? Did the part break and cause the accident, or was the part broken in the accident? All right?
I have a question.
Oh, we have a couple of questions here.
Well, you talk about misuse. What happens when the person who, in this example, like is on this device, and they haven't been properly trained, so they misuse it and it causes an accident?
That's not what we mean by misuse. Misuse is using product not for its intended purpose.
Yeah, intent purpose, right?
Okay,
Okay.
it's like you took the bulldozer out to the racetrack to race. Okay, not necessarily, but the bulldozer then.
The failure to train there could be liability against the employer for failing to train it, but when it comes back to a product's liability case, was there adequate instructions in the operations manual? Were there adequate warnings on the product as to what to do and not
Or
do?
is it just a misbehavior of the individual?
It's well, that's the whole thing.
If everybody's been trained, but there's a manager who doesn't follow what they've been trained to do.
And that's what happens in these lawsuits is somebody gets hurt and then they claim, I wasn't trained. The manufacturer will say, well, it's on the label. Well, I didn't see the label. I wasn't given the operator. And that's what's litigated for years, unfortunately.
Okay.
It also when the employee uses that defense, it gives the manufacturer the right to claim against the employer for the employer's negligence.
I think the misuse is probably very difficult to prove. So, in order to mitigate all the risks related to your product, do you think the statute of limitation will mitigate after a certain time, like the implied warranties as well as the warranties on the product?
Well, first of all, there is a statute of limitations, which in Illinois for product liability cases, personal injury cases, it's 2 years. It's 2 years starting to run from the date of the accident. So if the accident happens 6 years after the date the product was manufactured, then you have 2 years to file your lawsuit. To handle a situation where a suit may be filed 25 years after the product is manufactured or sold, we have a statute of repose which says, regardless of what happens, if you file suit 10, 12 years after the product was first manufactured or first sold, you have no right to sue under strict liability in Illinois. The breach of warranty statute under the Illinois Commercial Code is completely different. That's 4 years from the date of sale. 4 years from the date of sale. File suit. And so therefore, it versus both the statute of limitations and the statute of repose. Yes, sir.
It is manufactured outside Illinois or outside the US and then distributed in Illinois.
I'm sorry, what?
If the product is manufactured outside the US and distributed in Illinois, this statute of limitations still applies to that product. If you manufacture something outside.
Oh, outside the US.
Yes.
It depends on which scenario you're talking about. If you're talking about the contract claims, breach of warranty under the contracts, you got to go look at what law applies if it's addressed under the contract. If it's not addressed under the contract or the purchase order terms and conditions, there's a whole series of rules that the courts go through. If the person's injured in Illinois and you're applying what Bruce has just talked about, as Bruce said, the law of the state of Illinois will apply to that cause of action.
Yes,
You're talking about the clause which is normally at the end of the contract, it says that the jurisdiction will apply in, litigation will be applied in a certain.
And that will be, jurisdiction will be where the action can be brought if there's a dispute under the contract, but that does not determine what laws apply. And that doesn't apply between some third party that's not a part of that contract. So like in Bruce's scenario, the person that was under the bulldozer, he's not subject to the terms and conditions of the contract. He's not a party to that contract.
From an insurance perspective, the common cause in the general liability is that the suits have to be brought within the United States. What we've seen over the last 10 or 15 years is there are insurance companies that will add a coverage section for suits that are brought outside of the United States. There's a way that you could build a policy as well. It's something that's known as an excess difference in conditions, where in some parts of the world you cannot provide coverage. Your U.S. domiciled policy will act if there's a difference in conditions.
I think basically what we're saying is that as far as claims of third parties, injured people who are not part of your contract, you can't do anything about those claims in your contract. There are other ways to protect yourself. For example, if you're just a manufacturer and you're selling to an independent distributor here, you can require the distributor to indemnify you for such claims. All right? You can require the distributor, we'll talk about that later, you can require the distributor to have certain insurance policies that would defend you with the distributor of such claims. You can require the distributor to have an insurance policy with the vendor's endorsement. The things you can do in your contract or relationships to minimize your exposure to bodily injury claims. But you can't get away from them completely because the injured party is not part of your contract.
I think you just answered my question, that if there was something in the contract, I get this with my clients when I ask them this question, you know, what if somebody got injured by this product that's going in someone else's? Yeah. They'll say that's not my responsibility because it's in the contract that the manufacturer is going to assume that liability, but bodily injury trumps whatever that agreement is. It goes back to whoever was involved in making that whole machine.
And that's why you have to have commercial general liability insurance. Yeah. Okay. Give her your card. Yes, sir.
That's a general question. So in Illinois, there's special protections for distributors, but let's say the distributor is here in Illinois, us. The manufacturing is in another state, and the customer is in another state. Does it depend who brings the claim, whether that special protection applies? That
Illinois statute only applies, as far as I know, to accidents which happen in Illinois. Okay. As far as other states are concerned, I'm sure other states have similar statutes, so you have to look at the law of each state. There's generally, strict liability law is generally the same around the United States, and if you get sued for bodily injury, it's really going to be a strict liability case. But there will be differences among states, including whether you could use contributory defenses, negligence of defense, and also there'll be differences because of this retailer-distributor situation.
I just have one more little comment and recommendations. I had mentioned some trends that we're starting to see in the manufacturing industry. And it was ironic because I was meeting somebody earlier today and they just ran into this exact situation. So in the packets that are at the front desk, as well as I got some here, I've got some stuff that actually started in the construction industry. And this has been indemnification agreements, hold harmless agreements, transfer of risk has been something that we've seen in the construction industry for 30, 40 years, where you have a prime contractor that will require a subcontractor to indemnify, hold harmless them on a primary non-contributory basis, list them as additional insureds and all that sort of stuff. Probably going back 7 or 8 years ago, we started seeing insurance agencies and very sophisticated contractors actually tracking all of the contracts that you're entering into and making sure that your insurance requirements match what is required in the contract. So I'm sure you guys can't see this, but this would be an example of the indemnification hold harmless agreement, as well as the insurance requirements that are on the general liability, as well as any professional liability or errors and omissions, workers' compensation, all of that stuff is actually in the contract. What we've started to see within the last 2 years is that risk transference policy is trickling into the manufacturing industry. So the last one I saw was Medline was tracking a certificate for a medical device manufacturer that I work with, and they stipulated that they had to purchase errors and omissions coverage. So, from a best practices standpoint, what I've seen truthfully with all of our clients or people that we're working with, I would tell you that probably between 5 and 10% of people actually purchase manufacturing errors and omissions. It's not a large number. It's something that I would highly recommend, or at least to have a conversation to discuss the cost, do a cost analysis compared to the risk that you're taking. But in reality, I would say if my gut is correct, within the next 5 to 10 years, it won't be optional coverage. You'll have to purchase it if you're acting as a distributor, if you're acting as a manufacturer or supplier to an end customer. So that's kind of what we're seeing. One thing that I do want to point out too, this is another trend that we've seen, is cybersecurity. Obviously, cybersecurity is a huge topic right now. In terms of controlling costs from a manufacturing perspective, you can blend your errors and omission coverage with your cybersecurity. And you do that in an effort to lower costs as well as what's the real exposure. So you could buy $1 million manufacturing errors and omissions policy combined with $1 million cybersecurity policy, and essentially you cut your cost by a half or a third, something along those lines. We're also seeing that some of the cyber instances could lead to a manufacturing errors and omissions example. So we've had this, Taylor and I've had this, where you had a manufacturer whose system got hacked, and as a result, they could not meet their distribution requirements, so they missed their deadlines. So you had a client that was out of money, out of business income because you missed a deadline because your system was down for however many days. And now you've got a disgruntled client. So can you use insurance to transfer that risk? And that's the simple answer there. So
I would also suggest, just like some of the areas you covered, you can buy cybersecurity insurance. Don't expect they're going to cover everything. And they're going to come in and do an audit first. If they're going to decide they will insure you, and how much it's going to cost, or what you've got to do before you reduce the cost or can get insured. Because they need to make money too, right? So, yeah. And this is a whole developing area of business.
Yeah. The last little recommendation is, if you do start seeing that you're having to enter into contracts, I would make sure your attorneys are reviewing them, at least at the beginning, to make sure that you understand what you're entering into. But also your insurance agent looks at them, because if there are insurance requirements in there, the agent should tell you what you're in compliance with, what you're not in compliance with, but the cost associated with making sure you are in compliance. So that's all we have for you today.
I have another question, and there's a pattern I've seen over the last, being as old as I am, over the last 20-some years. There are things executives need to learn about, and if they choose to be proactive about it as opposed to getting sued and then react to it. How do you see this area here? How do you educate the executives and get them to do what they should do to be more protected and proactive as opposed to, it's just like a couple of years ago, executives say, oh, we don't need any of this insurance or stuff because we buy all this hardware and software. And it turns out that most breaches are not because of the hardware or software, they're human behavior. So how do you train, how do you educate the executives?
We could probably spend another 35, 45 minutes on that topic alone. But in reality, our job is just to make you aware. With CDH, Aki, I was so impressed with Aki, and she went back to school for her behavioral studies. And you could put the best financial package in place, you could put the best insurance policy in place, but if the human behavior is going to say there's no risk involved, at the end of the day, all I can hope to do is educate you. And I'm also a business owner. I'm realistic that there are decisions that you have to make because it might not be cost effective and you have to take on the risk, or you just don't see the risk. We see that happen often where this same client did not purchase cybersecurity, and within a week of that us making the recommendation, they disclose all of their employees' information. And truthfully, until I put the cybersecurity into their E&O policy, they didn't buy it even after they had an incident. So, yeah, that's,
Well, a lot of that is cost.
yes.
For years, there's been a recall exclusion in the general liability policy, and you couldn't do anything about it. Now, you may be able to buy recall insurance where you get that exclusion covered with an endorsement or something, but it's very expensive.
Yeah.
So a lot of manufacturers say, we'll take that risk, we won't insure that risk because the premium is just too expensive for that to have covered. And I think that may be true with a lot of the cybersecurity type situations where they look at the premium and they say, oh, it's not worth it.
Yeah, I would say the trends that we're seeing in cyber, real quickly, trends that we're seeing is that there are a lot more insurance companies now willing to do it than there used to be. So in 2001, I was on Chubb's insurance team that wrote the cybersecurity policy, and it was only available for financial institutions. Fast forward 17 years, you've got 70, 80 insurance companies that are willing to do it. We have a product that if you answer 8 questions, yes, and you do less than 20 million in revenue?
It's less than 20 or 25.
20 or 25 million in revenue. If you answer yes to all questions, it's $2,500 for $1 million worth of cybersecurity coverage. That's pretty inexpensive for the risk. So, go ahead. Yeah, no, I was just opening up the questions if there are any more.
Are there any other questions? Well, thank you for coming today, and you should see an announcement soon about our May risk seminar event. Our May topic is the new revenue recognition standard and adopting the new revenue recognition standard. So public companies have to adopt effective January of 2018. Non-public companies have to adopt effective January 1, 2019. And so we're going to go over the standard, and we're going to kind of walk you through some of the things that you need to consider and look at in preparing for this new accounting rule. And so just check your email. You'll get an announcement soon, and that will be in May 30th.
And I have folders outside as well as up here if you guys do want a copy of it that walks through some of that contractual liability. Great. Thank you guys.
Thank
for
you.
your day.
Thank you.
Oh.